Okay. Hello, everyone. We can't see you, but welcome to this CLE. My name is Mary-Maragaret Pingree, and I am the Executive Director of the Judicial Performance Evaluation Commission. And I will be presenting today with Justice Durham a little bit about the judicial appointment selection and retention process that we have in Utah, and also covering some of the most common misunderstandings about the process and common questions and myths that we see during an election cycle. So I've been the executive director of JPEC for about a year and a half. So now I have been through one election cycle and one evaluation cycle. And I work with commissioners to provide them with support as they work through the evaluation process, which is a complex and lengthy process. And today, as I mentioned, I am presenting with Justice Durham. She's one of our commissioners that brings insight to the process from a judge's perspective. And I'll give her a minute to introduce herself to you.
Thank you. One of the things I would say about my work in the area of performance evaluation is that I go so far back in the court system that when I first joined the district court and then a few years later went on the Supreme Court in the early 80s, essentially we didn't have a coherent branch of government with any branch of a judicial branch because of the governance problems. And it wasn't until the mid 80s that the Constitution was changed and Article 8 was completely reformed and changed to bring all of the courts under a single governance system. And at that time, the only kind of performance evaluation that was available was what was done by the Judicial Council, which was the administrative side of the court system. And so we were making it up as we went along back in those days with no budget, no additional staff. We really just had to make do. And then in the a few years later, there was a lot of focus on performance evaluation. And I was around at the beginning. We worked with the legislature, who was very interested at that point in time. And the system that we're going to be talking about today came to fruition in the form of a number of statutes. So I guess in some respects, I'm a little bit of the historian, but also being in my second year as a commissioner, I have finally mastered, I think, some of the complexities that Mary-Margaret mentioned. So glad to be here. Thank you so much for coming today.
And just in terms of a little housekeeping, we won't be able to hear you. So if you have questions, if you wouldn't mind putting them in the chat, we have someone from the bar kind of monitoring the chat, and we'll try to pause and answer your questions periodically as we go through the presentation. Hopefully we won't miss you. If we do, please feel free to reach out to me directly. I'm happy to answer questions. So today I thought we would start with the climate that we're in. And I know that as attorneys, you are very familiar with the climate that we're in. But we are always looking at data, and I found some interesting pieces of data that I thought you might be interested in and wanted to share with you. And this is the first one. These are relatively recent pieces of data. This was a survey commissioned by the National Center for State Courts, and it was done just a month ago in December of 2024. And it indicates that nearly 2/3 of Americans have confidence in their state courts. Second year of an increase in this, which is great given that 95% of all cases, that ways that people interact with courts are with state courts. They also found that a growing number of Americans are giving state courts a positive job rating. Their approval rating this year, or 2024, was 54%, and this is the fourth year of a positive trend. It's gone up 10% since 2021. So that's the first piece of interesting data I wanted to share with you, and I want you to contrast this with this next piece of data that shows confidence in the U.S. judicial system as a whole. This was a poll done by Gallup. It didn't differentiate between federal courts and state courts. But here we see that there's a sharp decline in the confidence people have in the judicial system. It's shown by the bright green line. You can see that there's a 35% confidence that Americans feel in our judicial system currently in 2024. One of the really interesting things to note is that is a 24% drop since 2020. So a very big drop in the last 4 years. Another interesting point is that there's a very large gap between the United States and other wealthy nations in how they feel about their court systems. The average among peer countries is 55% confidence, and the United States is 35%. So we have a big gap. You can also see confidence that Americans have in other systems. So the blue line at the bottom is in national government. The dotted line above the green line is faith in the honesty of elections, and then financial institutions above that, and the military above that. So with these kind of confusing, tumultuous times that these polls show, I wanted to pivot to talking about Utah's court and the system we use to select and retain judges. And so I'll pass it to Justice Durham.
Thank you. Thank you very much. Oh, I just noticed a question from the chat, and it is whether or not we can make these charts available. And I think we can do that. I think the bar can help us make those available and send out to participants. So my job is to talk about the actual selection and retention process. You have the issue of nomination and appointment, and you probably are familiar with those. They're governed by statute. One of the things that is important to know is that our system is a very strong system. It's called merit selection. That's the description of the system we have in Utah. And it goes from a process of a nomination commission, which is, well, historically, it's been bipartisan. The nomination commission. The last legislative session, the legislature actually made a revision to the statute on nomination commissions and removed the language that requires nonpartisanship in the selection of the commission members. So that's a little red flag to keep in mind, because it raises the concern that politics could enter into the nomination process, which would be a problem. The nomination commission interviews, well, first they look at the applications received from people who are interested in going on the bench. They then meet and conduct interviews with those who have been selected based on their applications. And at the end, depending on the court that has a vacancy and where things are being recommended, they have to send to the governor a certain number of potential appointees. Well, I don't even remember the numbers because they've changed recently, but for some courts it's 3, for some courts it's 5, and I think it's even higher for some of the appeals courts, although I've forgotten the number. Mary-Maragaret might remember. And then the next thing that happens is that when newly appointed judges have spent 2 years, or depending on the court they're on, it's 2 years for the district courts, for example, because they get reviewed approximately every 4 years. And the first retention process isn't a retention process at all, actually, although it is structured very similarly, in that the judges go through a complete review process under the rules and regulations established by our statute at JPEC. And what happens is that the retention part of it doesn't count but it gives the judges a chance to get the very same feedback that they will be receiving in a formal retention process. And it's structured in that fashion so that new judges in particular, and even older judges, when they do the mid-year retention process, we find that it's extremely useful for them as well. And what's so useful is that they get a chance to find out if there are any concerns about their performance. And then they become available for any kind of intervention or continuing education within the judiciary. So our system facilitates not just the retention to office for voter purposes, but also sort of bolsters the need of judges to get feedback on how they're doing their jobs and find out if there's any more work or events that they need to be attending. I skipped over appointment. Appointment, of course, is the governor's prerogative. And what happens is that the nominating commission's choices go to the governor, who then has his own selection process and often relies on staff to do any further background checks that he or she wants to do, and obviously conducts interviews and so on. The governor has the capacity to reject any of the nominations that come up. And I don't think we've ever had a situation where no one was selected. I think historically there's always been a candidate that comes from the nomination commission. So then moving into, well, let's see, let me make sure I just want to emphasize that in Article 8 of Utah's Constitution, Section 8, it says the selection of judges shall be based solely upon fitness for office without regard to any partisan political consideration. That is obviously a very significant issue when you're thinking about the independence of judges. So our system is designed to focus on qualifications, to provide accountability for judges, and to prevent potential corruption, which is always a risk when politics become part of the process. I think we're moving on to, have I left anything out, Mary-Margaret?
I don't think so, but I think there are some questions.
Oh, yes, there are some questions. Well, let me pull them up.
To read them.
Okay, well, here's a clarification. The governor has to select from those appointees. This is from Daniel O'Bannon. Thank you. If he doesn't, the Chief Justice makes the selection.
Oh, well, it's never happened.
And then here's a question. Doesn't the current process remove the politics from the public and place the politics of the selection process at the bar level?
Well, actually, the bar used to have the, I'm trying to remember the number of the nominating commissions. I think it's about 8 plus, I don't know if there are any ex officio ones, but the bar has never had more than 2 appointees on the entire commission. And actually the legislature last year also removed the bar's capacity to make appointments on the nominating commissions. So it would not be accurate to describe the nominating situation as controlled by the bar. The extent to which the governor might use lawyers on his teams or her teams and get some of the work done that way is always a possibility that there will be lawyers involved. And of course, lawyers will probably be asked in the nominating process to provide information or suggestions. But I should just observe that when I was Chief Justice for approximately 10 years, that was an era, it's no longer the case, but that was an era in which the Chief Justice of the Utah Supreme Court sat on every nominating commission in the state. So I attended and observed a large number of nominating proceedings. And I have to say that I can think of no instance in which either the influence of the bar, certainly as an institution, or even of the lawyers on the commission, or did I ever see signs of political intervention where people were working on political ends to the proceeding and worked on that through the nominating commissions. I haven't been on one of those for a number of years now, so I can't speak to how they're operating now. But the bar still doesn't have any kind of special control.
Okay, just a little bit about the Judicial Performance Evaluation Commission. We have 3 main focuses. And the first is we provide voters with information about judges. So there are judges on the ballot, and we try to provide detailed information about each of them so that voters can feel informed when they cast their ballot. We'll talk a little bit more about this a little bit later on. We also provide feedback to judges. Our goal is to have really strong judges, and we want to do everything we can to help them improve. When judges take the bench, from conversations that I've had with a number of judges, feedback drops off dramatically, and it's really difficult for them to see and understand what they might need to work on. And so JPEC is a tool that they can use to try to focus on, in conjunction with the Judicial Education Group, how they can make improvements in their performance. And then our third purpose is to promote public accountability of the judiciary. JPEC has 13 members, and they're appointed equally from each branch of government. So 4 from the legislature, 4 from the Supreme Court, and 4 from the governor. And the 13th member is the executive director of the Commission on Criminal and Juvenile Justice. It's a balanced commission, and it's set up to be balanced. And so only 7 of the members can be attorneys. The rest need to be citizen members, and only half can be from one political party. So the goal is to have a commission that represents a wide variety of backgrounds, different parts of the state, but in a really balanced way.
Thank you. By the way, let me intervene. I picked up another question on the chat, which I should address, and that's I curtailed my description. There is another stage of the selection process that I didn't mention, and that is that after the governor nominates, the name goes to the Senate for purposes of approval or non-approval. And we have had at least one instance that I can recall in which the Senate declined. And occasionally, actually, I can think of another incident which I found actually somewhat disturbing, and that is an incident where the Senate refused to hold hearings and make a determination on one candidate. So that person never moved to the bench. Sorry for the interruption.
It's back to you.
Oh, I'm sorry. I'm back. Looking at a lot of people, and I think a lot of people don't really understand what the substantive measures in the performance evaluation part are. And as you can see, they are legal ability, integrity, and judicial temperament. So that goes to performance in terms of the interaction with people. And then administrative skills, because judges have to manage their dockets and their cases. They also have to administer the courtroom process, of course, and the decision-making process. And then procedural fairness, which is focused on the ability of a judge to not just ensure that everything is done fairly and pursuant to applicable procedures, but also that people recognize that, the people who come to court, the court users, feel like they're being addressed, that their issues are being addressed, that they and their counsel are having an opportunity to access fairness and to be treated with humanity and, an assurance that they're being treated fairly. And then judicial discipline, which has to do with separate discipline that would likely go through the Judicial Conduct Commission created by the legislature a number of years ago. And that's where if a judge is actually charged with, or if the Conduct Commission itself comes to be aware of a disciplinary problem. So for example, if a judge should be accused of activity in the courts that was inappropriate, it would be for serious disciplinary matters. They investigate any allegations, they come to a conclusion, and for more serious discipline, the recommendation of the Conduct Commission gets moved up to the Supreme Court, and the Supreme Court reviews the investigation and determines whether the discipline that they've proposed is appropriate. And then finally, you have the Judicial Council doing certifications that relate to issues operating within the judiciary. So for example, there are time standards for the preparation of opinions. There's a continuing education requirement, and that's something Utah's really been a leader in the whole nation. We started with judicial education while very few others were regarding that as a significant part of judicial fitness. And then fitness, of course, goes to health issues and things like that. It's really important, and I'm sure probably all of the people who are here today, but it's really important to communicate to the public that the work we do in judicial evaluation is focused on a judge's performance, not the outcome of a judge's decisions. The decisions that a court issues belong within the judicial system. And we don't seek to assess the right or wrong of a particular outcome. We're concerned with the process. And it's also important to know that JPEC is only allowed to consider these specific measures that are in the statute. I know there are some people who are critical of JPEC's failure to look at the outcomes of a judge's decision, but that impinges on judicial independence, and it clearly impinges on the authority that the legislature has granted the commission in its statute.
Okay, so I want to just tell you a little bit more about how we gather data as we're looking at those specific performance measures. We specifically focus on two groups when we're gathering data. Groups that use the courts frequently, they're in court frequently, and then those who are served by the courts. So those who are in court frequently are attorneys. Many of you are in court frequently. Court staff, allied professionals, jurors, and litigants are in court frequently. We actually have not been able to get much data from litigants, only a little bit. And so we're working on some tests right now where we're trying to include self-represented litigants in particular more in the evaluation process. And then we want the voice of the average citizen to be part of the evaluation process too. We do that through courtroom observations. We have courtroom observers that go into a judge's courtroom 4 times usually during their term. And we train them, but they're not legally trained. They're not attorneys. There's a lot of things about the procedures that happen in courts that they don't understand, but they understand enough that they go in and evaluate procedural fairness. So they're looking to see, does the judge allow everyone to have a voice? Does a judge treat people respectfully? And ultimately, they answer the question, do I feel like I would be treated fairly if I were in this judge's courtroom? Yes or no? And that becomes part of a judge's evaluation. It's qualitative data, it's not quantitative data, but we do use it and consider it in part as we go through an evaluation. We also consider public comments when we're looking at evaluating a judge. Sometimes we'll receive public comments that will talk about the outcome of a case or the appropriateness of a sentencing. And again, as Justice Durham mentioned, we can't really consider those. It's outside our scope. But we do look for public comments, particularly for those who have had firsthand interaction with a judge and can provide us with some insight. And we include that as part of the evaluation.
Thank you. Let's talk for just a minute about the role of the commissioners. The first question we'll address is what commissioners look for. And obviously the first answer to that is they look for information, data, comments, for example, which are within the scope of what we can do under the statute. And that means that what we do not consider, as Mary-Margaret mentioned, is that we don't consider disputes about things like substantive judicial work and substantive judicial opinions. Even though, you know, those can cause a lot of grief amongst individuals who've been in court and have lost on points, or lawyers who believe they got a wrong result. But wrong results versus right results are not within our purview, and we try to ignore them. The other thing that we've done, and we've really bolstered our ability to stay as neutral as we can in all of our work. And one of the things we've worked very hard to do over the last, it's been about 4 or 5 years now, I think, that we have been focusing on ensuring that the reviews we do are as blind as possible. And so, for example, in the comment process, we ask our staff, without our oversight, to ensure that the comments we're getting don't reveal a lot of things about the judge that would be irrelevant to our work. So, for example, their race or ethnicity, perceptions that you know, if the perception that we're looking at is that someone has been perhaps abusing the position of a judge to incorporate his or her religion or politics, and so, and that would be legitimate for us to see, because that goes to procedural justice, and it also goes to bias. And so we can look at that, but we want to make sure we eliminate bias on our perspective, from our perspective, and try to keep our reviews as neutral as they can possibly be. And really, even in the time that I've been on the commission, there's been a lot of work on behalf of the commission and the staff to make that part of the process better. And then I can say that both before we had JPEC and after we had JPEC, I was on the court for a long period of time and had a number of reviews, both for retention and mid-year reviews for education and information. And I have to say, it's a difficult process. Anybody who's ever been reviewed for performance knows that you run the risk of finding out things that might not make you completely happy about yourself. On the other hand, it is so interesting, in my experience, to realize what you don't know about yourself, or what you know about yourself, but you don't know how it's affecting other people. So I think we're going to move now into some actual records that we have that we can use as examples. But the other thing I would observe is one of the opportunities I've had since leaving the court and serving on JPEC is to go back to the Judicial Council, usually on a yearly basis we go, and report on what we're doing. But it has been really rewarding to see when JPEC was first created and you had external reviews of Utah judges as opposed to the internal reviews when the Judicial Council was doing them. And a lot of judges were very concerned about that and concerned about whether they would get a fair shake. But I have noticed over the years that for the most part, the judges, even the new judges coming in who've only heard about it, are quite positive about the work that JPEC has been doing. And, you know, there are problems. There are always problems with data. There are always problems with definitions. And one of the things the commission has to do is constantly be doing revisions ourselves and trying to get closer to as much accuracy as we can manage.
Okay, since I want to pivot a little bit to the most recent election and share a bit of information about the election, starting with what we share with voters. So many of you know our website is judges.utah.gov, and I just wanted to quickly show you some of the things that we share with voters, and you being a voter, hopefully have been on this website and seen them. This is an actual screenshot of our website right now. So Judge Barnes gets to be a guinea pig because he's at the top of the list. But this, when you search for a judge, this is the top screen that you see, and it gives you information, the judge's name, what court type they're in, what location they serve in, and then the big green button tells you whether that judge met or exceeded the minimum performance standards that are in the statute. You can also see how the commission voted on each judge. And then the last column is will be familiar to those of you who have completed a survey. It's the number of respondents who complete a survey who said, yes, I would retain that judge. If you click on this View More button on the left-hand side of the screen, it will take you down to more detailed information about a judge. And this screen shows you a summary paragraph that we do for every judge. And this is a summary of all of the data that we collect, because we know that you don't always have time to dig into every detailed piece of information. You can, we provide it on the website, but if you don't have time and you just want to quickly glance through and get an overview of a judge, this is the place to go. I just want to tell you a little bit about this paragraph. The first sentence tells you how this judge compares to his or her peers. So this particular judge, Judge Barnes, is statistically consistent on those performance measures that we talked about with his peers. Also, in the middle of the paragraph, what the commission will do as it's gathering data is look for themes. So we receive a lot of data, a lot of comments about each judge. And I know that judges sometimes get concerned that if someone sends in a really negative comment, that it's going to damage them in their evaluation. But what commissioners are really looking for is themes. If there's one person that says something and nobody else is saying it, that's not a theme. So it's usually a group of people together that are saying the same thing. And we look for those themes, and then in the middle of the paragraph, we will tell you what those are. So in this particular case, this judge, this came from courtroom observers and from survey respondents. This judge has a calm, kind, and considerate judicial demeanor. Also, this judge is diligent and efficiently manages the courtroom and is willing to listen to all sides. So those are the themes that we found in all of the data. If you don't want to spend time sifting through it, we do that for you. We also, go ahead.
Well, a question has come up in the chat as to whether people looking at the website can look at the verbatim contents of the comments, or do they have to rely on the summary?
We do not publish individual comments verbatim, and that's kind of to protect confidentiality of the people that are leaving the comments. So we do provide a summary and not the individual comments. Another thing that you can find in this paragraph is we ask through the survey respondents to rate judges on specific characteristics. So this particular judge received very high ratings in terms of decisive. So you'll see in those different adjectives that we ask people to rate a judge on, if someone does particularly well or particularly poorly, we will put that in this paragraph. And then we will talk about the courtroom observers and what they saw. You will see how many of them expressed confidence and how generally they felt about the judge. The last sentence is all about the standards from the Judicial Council and from the courts, whether they meet those standards or not. If you scroll down on that same page, you can see the data in a little bit different way. So this judge's score is the top bar, the dark blue bar is this judge's score in legal ability, for example. The yellow bar is how other district court judges did on this particular performance measure. And then also the green bar is the minimum performance, so that you can see the data in a little bit different way and see how this judge did. You can also see a summary of what the courtroom observers thought. So you can see, we again look for themes in what courtroom observers see in the courtroom, and we try to put those in a paragraph for you so it's easy for you to quickly glance at them and see what they are. We also list things that they say that don't rise to the level of a theme, so that you can just get a really good sense of how the average citizen views this judge. And then you can see the answers to individual questions as well and how the judge scores in each of these specific areas. So if you have a concern in a specific area or a specific topic is particularly important to you, then you can go and look up how that judge rates in that particular area. And those of you who have completed surveys should recognize these questions. And you can see the judge, and then you can also see that judge compared to how other judges, his peers or her peers, performed. Okay, so I want to tell you a little bit about the election and judges and the results that we saw. There are a couple of interesting things that we noted in this election. The first one is, and many of you, I get asked, I know, by your neighbors and friends how they should vote on judges. And you'll notice that almost half of the judges on the ballot this time around were new judges. So I think there were a lot of attorneys who didn't recognize a lot of the names that were on the ballot. And, you know, a lot of first-time judges. You can also see the range of votes in this particular election compared to other election years. This year, the high was 85% yes votes for a judge, and the low was a little above 72. That's a very narrow range. You can see other years, the range has been wider. There's a reason for this that I'll tell you about a little bit later, but it is a narrow range, and we know why that is. Are there any questions, Christine, that I need to answer?
Yes, actually, there was a question going back to the courtroom observers, and the question is whether or not they are anonymous. And I think the answer is they are anonymous to us. Anonymity in the actual court observance process is difficult because they when they can, they attend court in person. And so a lot of judges and their staffs are probably sensitive in certain matters to know who's in the courtroom and may even ask questions. So it's hard to preserve anonymity vis-a-vis the parties and the lawyers and the judge in the courtroom.
Yeah, that's true. We ask them to try to be anonymous if they can. We ask them not to introduce themselves to the judge. but sometimes, particularly in juvenile court,
Mm.
there's a sensitivity to who's in the courtroom, and they will be asked who they are and what they're doing, and then they'll tell them that they're a JPEC observer. So we try to keep it anonymous, but it doesn't always work out that way.
But we don't know who they are.
Oh, commissioners? Yeah,
Right.
commissioners don't know who they are, no. This is also just a summary of the different levels of court and what the yes percentage was for each level. So Supreme Court, it was 77%. In 2024, District Court was the same, and Juvenile Court was a little bit higher at 80%. Back to you.
Thank you. So now we are looking at, let me make sure I'm on the right page. Looking at attorney surveys, which is really, it's critical for us, and we hope that it has become increasingly critical for members of the bar who practice in the courts, and our responsibility as lawyers generally to do what we can to improve the quality of judicial performance. So the surveys that we get from attorneys are really important. And you may have noticed that in the last few years, we were able to persuade the bar to approve CLE credit for completion of surveys in certain circumstances. And that has improved the level of response, and it's been very helpful. And what's, as the chart here indicates, the things we get from attorney surveys are insights of people who are actually consumers of judicial services and judicial performance. And the second issue is the size of the pool. Anybody who knows anything about statistics knows that the smaller your sample, the less reliable the outcome is. And so it's really important to get a decent pool size. And I just mentioned one of the things that we are struggling with and working on is trying to figure out how to extend the pool size for appellate judges, because appellate courts don't work the same way as trial courts, and they the insight that someone might have into the work of an appellate judge is going to be quite limited in many ways, because appellate courts work like committees rather than individuals. And so we're doing some experimentation and trying to get some data about expanding the pool. It's easier in the trial court, and we are so dependent upon lawyers. We also, as Mary-Margaret has mentioned, and I'm sure you all get phone calls or comments at lunch and so on, asking you who to vote for on the judge list. And so one of the things you can do now, of course, is to just write down the website for JPEC, judges.utah.gov. But at the same time, even if you don't tell them for whom you're voting, your reference to JPEC for the data that's there has some credence, because voters do look to attorneys for direction when voting. In the early days of JPEC, the commission used to recommend or not recommend retention. And it was determined over time that was really not an appropriate function for the commission itself, that our responsibility was to provide good data so that voters could look at the way judges were being rated and received and appreciated or not by the people who were interacting with them. And so these days we don't make any recommendations. We just opine on the question of whether people meet or don't meet the standards that are at issue. Okay, we're going to move on. If anyone's got any more questions in that area, go ahead, Ray, and put anything on the chat. I'll watch it.
Okay. while you do that, I wanted to kind of close out our lunch hour today with some common misunderstandings, misconceptions that come up, and I noticed them just particularly during the election cycle about JPEC. So the evaluation process is a really complex process, and we try to make it as visible and transparent as we possibly can. But we're dealing with sensitive data about individuals. And so some of that information just can't be shared publicly. So as a result of that, we get a lot of questions or misunderstandings about why some things are the way they are. So I wanted to share some of those with you today, because I heard them so much in the months leading up to the election. The first one is the perception that voters don't ever even use the evaluation data that JPEC provides. And so in the months leading up to the election, I was really interested in whether voters do use this data, because this is one of the purposes of JPEC. And if people aren't using our data, then we're not fulfilling the purpose that we have. So I talked to a lot of voters, and sometimes I would hear, yeah, I love that data. I use it every time I vote. It's so helpful. Thanks for providing it. But just as often, I would hear, JPEC? I've never heard of JPEC. And so anecdotally, it was really difficult for me to tell whether voters were accessing this data and using it. So because we're a data-driven organization, we decided to turn to the data, and we looked at election and evaluation data back to 2014 and found that there is a very strong correlation between a judge's score and the number of yes votes they received when they go on the ballot. And also that as a judge's score increases, and you can see the line here on this graph, as a judge's score increases, so does the number of yes votes they get. As a judge's score decreases, the number of yes votes also decreases. This doesn't mean that everyone uses JPEC data. We know they don't. And it doesn't mean that we couldn't do a better job of trying to communicate the information out to voters. What it does mean is that there's a strong correlation, so we know a number of people are using JPEC data when they vote. And we also know that about 300,000, we had about 300,000 visits in the 2 months leading up to the election at judges.utah.gov. Is there a question? I saw that.
I was just checking. It's actually not a question, and I'll save it to the end of this because it's information on whom to contact to get your CLE for filling out
perfect.
surveys.
Okay, great. Okay, another kind of myth that we saw is the feeling that people don't really spend time voting on judges. Judges they run in uncontested races, and it is true that uncontested races don't generate as much interest as competitive races. Their placement on the ballot is towards the bottom of the ballot. And so sometimes that'll lead to voter drop-off. So we looked at the percentage of registered voters that voted for judges this year and found that 83% of registered voters in Utah voted for judges. Well, we thought, well, that's interesting, but how does that compare to other races? So we looked for all the other uncontested races there were in Utah, and there were quite a few state House and Senate races this year that were uncontested. And so we compared those to judges and found that they're all in the same range, uncontested races between 80 and 83%, and judges even did a little bit better than other uncontested races in the state. Then we wanted to look at how Utah compared to other judicial retention states. So there are a number of other states that have a system that's similar to ours. And so we tracked down data from those states to see how Utah was doing. And Utah voters actually are more engaged than voters in other judicial retention states. With Alaska, New Mexico, and Colorado falling below Utah, Utah claimed the top spot. So Utah voters do engage on judges, even though there are some characteristics about the elections that make them not as interesting or enticing as competitive races. And this is the question that I probably heard the most often. And that is, well, the comment that all judge reports are positive. The JPEC's just a rubber stamp for judges, and there's not much differentiation between judges. And there's a reason why this seems this way that I want to explain. And that, well, first of all, not all evaluations that JPEC does are positive. JPEC prepared 60 evaluation reports this year. Not all of them are positive. Justice Durham can attest to that because she was intimately involved in those evaluations. But we send out those 60 reports to judges who were eligible to stand in a retention election, and we send them out in May of an election year. That gives judges a couple of months to read through their evaluation report, digest it, understand it, and then decide whether they want to put their name on the ballot. It is usually the case that if a judge receives an unfavorable evaluation, that they decide to resign or retire rather than to stand for retention election. And if a judge does that and they decide not to stand for retention, then their report is never made public. It stays private. So in 2024, this is exactly what happened. All judges who received unfavorable evaluations stepped down, and so no negative reports were made public. And so that's why you kind of saw that narrow band that I mentioned I was going to come back to between the lowest yes vote percentage and the highest yes vote percentage, is that the people who received unfavorable evaluations actually decided not to put their name on the ballot. And so their reports weren't shared publicly.
I think it's important to add to that overview that whereas all judges with unfavorable evaluations step down does not equate with the notion that anyone who stepped down got an unfavorable evaluation. There are all kinds of reasons for retiring or deciding not to run again, including, personal career goals, health, time of life, planned retirement, etc. But the fact that it is the case that the vast majority of people who do have unfavorable evaluations step down. And I also wanted to add, we had a question about anonymity with respect to observers, and I talked about the anonymity of the judges when we're doing our review. Towards the end of the review, when you get ready to prepare the election information, of course, we have to have the names of the judges. And what that means in part is that if there's a judge with a problem in his or her evaluation, we can invite them to come in and meet with us, or they can request that they have an opportunity to come in and meet with us, to have a conversation about what there is in their data, to ask any questions that they have, and to give us a deeper look into what the situation is and so on. So I think, are we at the end of this? Because I've got a couple more questions.
Yeah.
And this is a really good one. And it is, who sets the performance metrics? Okay, I have to see the rest of it. Oh, there we go.
Who sets the
Yes, who sets the performance metrics or criteria, and can they be changed? Excellent question. And then actually a comment here that it would be helpful to the public for them to know that all judges, well, that's an interesting question, that all judges with favorable evaluation step down, but also others step down too. Would that be an appropriate inclusion on our website? Or is that one we give to the press and let them deal with it? Not sure.
Yeah,
first of all, let's talk about the performance metrics, because that's, that's it's a difficult issue. We have a lot of statisticians and very talented people on our staff, and we need them.
Oh,
I just
Well,
wondered if you had an observation on that.
about the performance metrics and where they come
Right.
from. They come from statute and also rule. So most of the performance metrics, 3 of the 4 are in statute. And so they were determined by the legislature when JPEC was introduced. We have in the interim between 2008 when JPEC was established and now added a performance metric, and we have the ability to add performance metrics by rule. And so one has been, the procedural fairness metric has been added by rule. So they come from a couple of different places.
And it's a difficult situation. I mean, I know Mary-Margaret in her presentations around the state and to different constituencies, including voters and legislators and so on, you hear people saying, you know, why aren't you testing or including various issues? And sometimes it's things like case outcomes, and in some instances it's based on politics and so on. And we have to maybe do a better job at communicating what we have and where we got it from in terms of our metrics. So that's a good question. And then the issue of whether or not we could publicize more aggressively the way what gets published and what doesn't get published in the final final process. You don't want to, you know, cast any aspersions on the people who haven't earned them. And so you have to be very careful with the language you use, but it's something we will talk about, put on our agenda.
Sounds good. Okay, Christine, I'll let you wrap it up.
Well, we wanted to include this particular citation because in the process of creating our Judicial Performance Evaluation Commission, one of the first of its kind in the nation, we worked closely with the Institute for the Advancement of the American Legal System, AALS, and one of the founders, and including Jordan Singer here, who is also one of the founders of this project, came and worked with the Utah legislature and with a number of judges who were on the commission who was taking over, you know, trying to figure out what this should look like. And Professor Singer from Harvard Law, and who consulted on the project, said the Utah legislature wisely committed to a comprehensive judicial performance evaluation program. And very few, if any, had such a thing before Utah became a leader. That program is a national leader today, helping our judges improve on the bench and helping Utah citizens maintain the accountability of their judiciary. It's a very, I think, impressively balanced process that is doing a good job for Utah, which is not to say that the commission and that the legislatures who oversee it and the judiciary itself are all pretty vigilant in trying to make sure we're doing the things that keep it as good as it is now and try to make it better, because you can always make it better. And the more we learn about statistics, the more we understand that. And then let's see, our last one here is to say that Montana has offered us a big compliment. Their legislature has just, in this session, 2025 session, are going to create a judicial performance evaluation system, and they've decided to use our system as a model. So legislative staff have turned to Utah for advice and direction in creating a successful commission, and Mary-Margaret has a big job in teaching now as well as everything else. Let me just check. There's one more comment. Where are we? Oh, someone says, sorry if this was answered, but will there be a similar process for commissioners to evaluate commissioners? I'm not sure I understand the question.
Oh, commissioner judges, commissioners,
Oh, I'm sorry.
yeah, you're thinking you as a
I
commissioner.
was thinking JPEC commissioners and I was confused.
Yeah, there is a similar process, but it's run by the courts. And
Right.
they do kind of an internal evaluation of commissioners.
Yeah, and the reason for that so far is that commissioners are appointed by the judges in the first place. So they're in charge of the nomination and selection process. And therefore they've inherited the attendant provisions or the attendant work for purposes of evaluation. So, and that could change. We've swept in, our system has swept in justice court judges, and they're part of JPEC. So it's a pretty big system. Well, thank you so much for your attention, for the questions, and do feel free to reach out to Mary-Margaret, and she'll bring things to the commission. If there are things you'd like us to think about, if you still have questions that are unanswered. And I've noticed that you should have all seen in the chat that you don't have to worry about registering for CLE for this event. Zoom tracks us all and knows you've been here.
And I'll send the slides to the bar and they can get them out to you. So thank you very much for coming today.
Thank you.